All right, good morning. Can everybody make sure the audio is muted on your laptops? Okay, we are here for jury selection unless there's going to be a plea. So what's the decision, Mr. Johnson? All right. Let's swear him. If you can stand up and come to the podium. Can one of y'all come up and swear him, please?
Please, Brian. You taught us well, Brian, that when we were on the court, you told us to know what you got. What's the record state and say the first last name? Christian Evans. Spell out. C-H-I-S-T-I-N-G-E-R.
All right. Who's going to be handling this for the state? All right.
Mr. Eppinger, are you at this time taking or under the influence of any alcohol, drugs, or medicine? How old are you? And how far did you go in school? Are you able to read, write, and understand the English language? Do you understand that you are charged with the following charges in this indictment? Count 1, conspiracy to violate the RICO Act, which carries a sentence of 5 to 20 years. Count 27, armed robbery, which carries a sentence of 10 to 20 years or life. Count 28 of this indictment, hijacking a motor vehicle in the first degree, which carries a sentence of 10 to 20 years and a $10,000 to $100,000 fine. Count 29, possession of firearm by first offender probationer, which carries a sentence of 1 to 10 years. Count 31, theft by taking, which carries a minimum and maximum sentence of 1 to 5 years. Count 32, attempted murder, which carries a sentence of 1 to 30 years. Count 33, attempted murder, which carries a sentence of 1 to 30 years. Count 34, possession of firearm by first offender probationer, which carries a sentence of 1 to 10 years. Count 35, possession of firearm by first offender probationer, which carries a sentence of 1 to 10 years.
This is what you're charged with?
Yeah, this is what you're charged with. Count 36, possession of firearm during the commission of felony, which carries a sentence of 5 years to serve consecutive to any other count of indictment. And possession of firearm during the commission, count 37, possession of firearm during the commission of felony, which also carries a sentence of 5 years to serve consecutive. Count 38, participation in criminal street gang activity, which carries a sentence of 5 to 20 years. In count 38, another count of participation in criminal street gang activity, which carries a sentence of 5 to 20 years. And count 47, conspiracy to commit a crime, which carries a sentence of 1 to 10 years. Do you understand that you have the right?
Hang on. Isn't there a 48 also?
And count 48, criminal street gang activity, which carries a sentence of 5 to 20 years. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Have you had enough time to speak with your lawyer, Mr. Johnson, about all the facts and circumstances known to you regarding the charge of this indictment? Have you spoken to him regarding any potential defenses? Do you need any more time to discuss this case with your attorney? Are you satisfied with his counsel and representation? Do you waive formal reading of the indictment? And do you waive any defense, if any, with respect to the indictment? To your knowledge, have you been arrested?
Hang on. Mr. Johnson, that's normally addressed to the attorney. Do you waive that?
Yes, Your Honor.
All right.
Do you waive, have you been arrested on these charges, Mr. Eppinger?
No.
And Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Johnson, do you know of any outstanding warrants related to these charges?
Whenever you start talking.
And Mr. Eppinger, I just advised you of the minimum and maximum for these sentences. Are you aware of them? Do you understand that in pleading guilty to armed robbery, you're pleading guilty to a serious violent felony? Do you understand that you will serve the entire prison portion of the sentence imposed for a serious violent felony without the possibility of parole? Do you understand that while you would be eligible to be considered for participation, yes, in the Department of Corrections Administered Transitional Center or work release program on the final year of your incarceration, you will not be eligible for any other sentence reducing program of the Department of Corrections or Board of Pardons and Parole? Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections? Do you understand that this plea is a blind plea, also called a non-negotiated plea? And the state will recommend a plea. Your Honor, can we do what our recommendation is at the end?
That's fine.
Okay. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that which is recommended by the state? Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced? Do you understand that this is a guilty plea which is permanently recorded on your criminal history? Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal court? Do you understand that you are currently on probation or parole? Your probation or parole may be revoked based on your entering a guilty plea today. Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws in any governmental units or any special conditions of probation without being subject to revocation for the balance of the sentence? Do you understand that you are not allowed to possess or use a firearm on probation? Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial, and that this is true regardless of any advice by your attorney or anyone else? Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison? Do you understand you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are given the following rights? And Mr. Eppinger, I'm going to ask you to say yes, ask each right that I see.
Well, say yes if you understand that that's a right that you're giving up and you want to give that up. Say no if that's not the right answer. Say I don't understand if you don't understand. Okay?
The right to a trial by jury.
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses and witnesses. Your right to assist with counsel hired by you or to court-appointed counsel if you cannot afford an attorney in the trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence. The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have a charge against you proved beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial. Has anyone forced, threatened, or promised you anything to get you to enter a plea of guilty?
No.
It is my understanding that you're asking the court to consider this plea under North Carolina versus Alford.
And is that every count that he's going to be pleading to?
Yes, Your Honor.
All right. Well, I'll have to hear why.
Is it your decision to waive these rights and enter a guilty plea because you are a felon? Guilty, or are you pleading under, or asking the court to plead under North Carolina v. Alford? Are you pleading guilty because you have decided it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and puts you in the same position as if you were convicted by a jury at a trial?
Yes.
Now, Mr. Eppinger, based on the negotiations, do you understand that you are pleading to the following
state's gonna move, you're, as a part of this plea, going to be null crossing certain counts?
Yes, sir.
All right, what is the state moving forward on?
Your Honor, the state is moving forward on count 1, conspiracy to violate the RICO Act. Count 27, armed robbery. We are going to null cross count 28, hijacking a motor vehicle in the first degree. We're moving forward with count 29, possession of firearm by first offender probationer. We're moving forward with count 31, theft by taking. Count 32, attempted murder. Count 33, attempted murder. Count 34, possession of firearm by first offender probationer. We are null crossing count 35, possession of firearm by first offender probationer.
Count 35 was dismissed, so that's not no crossing.
Oh,
Excuse me, Your Honor, during the first, charge. Count 36,
wait, back up. What do you mean by the first
during
charge?
the first series application, Your Honor, that case. Count
35 was,
Yes, Your Honor, the defense, we filed a motion to have that count dismissed.
All right.
We put the vehicle count
all
number
right,
34.
okay.
Count 36, possession of firearm during the commission of a felony. We are null crossing count 37, possession of firearm during the commission of a felony. We're null crossing count 38, participation in criminal street gang activity. He's pleading to count 39, participation in criminal street gang activity. Count 47, conspiracy to commit a crime. And count 48, participation in criminal street gang activity. Mr. Eppinger, with respect to those charges, if I need to read them again, how do you plead to those charges to which you're pleading to?
Yes.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges you receive?
Yes.
Do you understand you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date for the felony, for all the felonies, to file a habeas corpus petition challenging the constitutionality of the guilty plea?
Yes.
Do you also understand you have 30 days from today's date to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion to withdraw this guilty plea, which does not mean it will be granted. That's just a time period that you can file. You understand that?
Yes.
And Your Honor, in this case, we're going to go to trial.
Is this something that's on Zoom?
Yes, Your Honor. The state would expect to show a number of different things as we move forward with this indictment, Your Honor. As you have heard, this is the YSL RICO indictment in which the YSL gang is an enterprise consisting of a group of individuals associated with that. Although not a legal entity, they were started in 2012 in the Cleveland Avenue area of Atlanta, Georgia, and they claim affiliation with the National Blood Gang. The founders were Jeffrey Williams, aka Young Thug, also known as Slime, Walter Murphy, also known as DK, and Trontavious Stephens, also known as Love. They identify with a variety of identifiers, including colors, clothing, tattoos, and hand signs, as well as verbal and written identifiers. They often wear clothes with the word Slime and YSL, and also have tattoos with the name YSL. Specifically for Mr. Eppinger, Your Honor, he has several cases in this indictment. Your Honor, under count 1 of RICO conspiracy, Mr. Eppinger had an armed robbery in May of 2016 with the victim, Xavier Hill. He was convicted of that crime, spent 4 years in prison, and was released in May of 2021. In October of 2021, Your Honor, he did the armed robbery of Mr. Darius Smith.
All right, so did that May 11th armed robbery, was Was that a first offender
It
conviction?
was a first offender conviction, it was reduced from armed robbery to robbery. And I'm gonna go into more detail on each and get an overall timeline. In January twenty twenty-two, there was a theft by taking. About 3 weeks later, on February 7th of 2022, was the attempted murder of Officer Rodgers and Sergeant William Johnson. And then in February of 2022 was a conspiracy to stab and kill Mr. Rashawn Bennett. You're right, we went over the crimes that were charged in this indictment. So again, on May 11, 2016, which is Act 61 of Count 1, the RICO conspiracy, this happened at 245 on Mall Drive Southwest, which is in Atlanta, Georgia, in Fulton County. The victim, Ms. Taravia Hill, was coming home that day with her daughter. Mr. Eppinger arrived in the subdivision with 3 other males in a vehicle. He got out of the car, held Ms. Taravia Hill at gunpoint in front of her daughter, robbed her, took her vehicle, and went on and fled the area, Your Honor. He was picked up about an hour later off of Cleveland Avenue, where he actually got into a car crash off of Cleveland Avenue. This is some of his in the middle picture, the picture of him on social media in and around the time of this armed robbery, Your Honor. That is, the picture on our left is the area where Miss Taravia Hill was robbed, and then that is the car that he stole from her, and then ultimately got into a car crash. And at this time, Your Honor, Mr. Eppinger was going by the moniker on his Facebook page, YSL RICO. His name is Christian, but he changed the B to C with the same monikers that the blood had used back in the day. As I mentioned, Your Honor, he was convicted of this crime in December 2016 with a negotiated plea. The victim, Ms. Hill, came in, understanding he was 16 years old at the time, asked for leniency for him, in which his armed robbery was reduced to robbery, and he received a sentence of 10 years instead of 4 years, balanced on probation. Mr. Eppinger got out of custody in May of 2021. Within 5 months of that time, he was back on the block of Cleveland Avenue with his YSL associates. In this picture specifically is Durante Beebe, and Mr. Eppinger is in the middle, wearing Keep America Slime Against flat clothing, and all of those same monikers that came with YSL in the gang. And this is on September 29th, 2021.
And was there a probationary condition that he not be connected with non-gang members?
Yes, Your Honor. Within 3 weeks of that picture, Your Honor, we had the armed robbery of Darius Smith on October 12th, 2021 at 47 Cleveland Avenue, which is also known as the Cleveland Avenue Park. This is where a number of YSL gang members hung out.
And this is going to be counts 27, 28, and, well, 27 and 29
Yes,
of our indictment. Okay.
And while Mr. Darius Smith was at the park that morning, hanging out with a friend because he was waiting to meet his brother, the defendant, along with Durante Beebe, approached Mr. Darius Smith, holding a gun to his head and to his side. They stole his watch, his chain, his earrings, his wallet, and ultimately they also stole his right ear. This happened about 4:15 or 4:45 p.m. That afternoon. While there are kids, this is a library, Your Honor, so in the front of the park is a library, and in the back is a playground area. This is just some of the surveillance video, Your Honor. So what you're going to see in this surveillance video in a few moments, we believe that the robbery happens to the left of the screen, so where the cars are coming from. And so you can't see the robbery off camera, but what you're going to see, and I want you to notice, the adult woman, they keep looking in that direction. We believe this is where the robbery is taking place. You see them rush and get into the car, and then you're going to see another young man come down the steps. and she kind of flags him and tells him to hurry, so we believe this is the point in time the robbery is ending, and the vehicle that's stolen is in the background of this video. For this case, Your Honor, the state had phone records. We were able to get the phone records for Durante Beebe. He was using his phone at the time, or in and around the time of the armed robbery. Mr. Eppinger was not. What we have is, at the bottom of the screen, Mr. Beebe's phone pings in the location of the robbery, and then we see his phone pinging later on in the afternoon, so where the car was recovered, which was not in the same location. The car was actually recovered at the village at Castleberry Hill, which is about 10 minutes or so from this location. This is the victim, Mr. Darius Smith. You see him wearing his chain prior to the armed robbery, which was one of the most significant pieces that they stole because his chain was very distinctive. At the time, he was a rapper. He went by the name of Trap Commander, and the chain says Trap Commander on it. After the robbery, we had Sergeant Pierre, who was the lead detective on this case, was able to get Instagram records of both Durante Beebe and Christian Eppinger. And what we found after the robbery, Durante Beebe is holding the chain, so that's him on the end. And then we found that Mr. Christian Eppinger, we believe, actually bragged about the robbery, and that's the video that's going to come next.
But he's somebody from every county. Yeah, I ain't going about that. You gotta leave. What do you mean? You need 5,000. Hey, boy.
My time, baby.
Get to the Willie.
I'm ready to be still. I'm not, you know.
I brought out in there. Took everything. I took it, Chinese, you roll it. Oh, no. No, that's what I did. But no, he thought that I was. Don't notify.
How much I can get from the phone?
What?
From the phone?
I don't know about you. So I know. Keep the buy that. No? So you can get 50,091. Yeah, I'm gonna put that. I ain't gonna wait. Hey, you wanna win? I got flat. I'll take that. I'll take that 9 now.
Let me see that bit. It's busting outside.
Put it down, man.
All right, that's hurt.
Huh?
That was very good. Well, everyone there? You can tell that the everyone light him.
Oh, no, I ain't gonna. Catch it again, take your time again, make it buy it back again. But just saying what you did when I took the gun off. You can have it. You can have it. I got it. Huh? I made him sit down on the curb. He thought he was gonna get me. I put out and sit down on the curb. I seen the earrings in the ear. Oh, take the earrings out too. He told me you gonna do it like that? Yeah. What?
Hey, Your Honor, so in that clip, he's talking about taking the chain and he's trying to sell it back to the victim. He also talks about the watch, the earrings, and all the items that were taken from Mr. Smith. And then he talks about the fact that he put the gun to him and put him on the ground. When we met with Mr. Smith, just to understand what happened to the kid, I asked him, what happened to you? He said, the defendant put me on the ground, he made me sit on the ground before taking the items. And so we believe that this is him bragging about that armed robbery, and this was posted about 4 days after the armed robbery. The next, Your Honor, we have overt act number 149. Again, Mr. Eppinger is with 3 other YSL associates, Durante, BB, as well as Mr. Rooney Lee, also known as Slime Like Shorty. So again, posting pictures in the same clothing, OTS, only the slime clothing. Then he's posting on social media, Cleveland gave me the game, YSL gave me my name. We were studying back then, we wasn't studying the thing. Free ESPN, which we believe every slime plays nasty. The real ones, not the play plays. So again, him posting about the game, and then him with guns and things of that nature, this is all on his social media. Then we have January 22nd, 2022, Your Honor, which is count 31 of the indictment of theft by taking. This is at the Zaxby's on Northside Drive. The victim in this case, Mr. Willie Moore, was a Uber Grubhub driver. He was picking up an order for a customer. He walked inside of the Zaxby's, and this is the surveillance video from that incident, Your Honor. That's Mr. Eppinger in the black hoodie. That's Mr. Moore walking to the Zaxby's. Mr. Eppinger turns back around, leaves his friends, gets into the vehicle, and then drives off with the vehicle. Mr. Moore did not give him permission to drive that vehicle. After this incident, a bolo was put out. Members of APD gang unit, Mr. Sergeant Johnson, they were able to immediately identify him as Christian Eppinger. The car was later recovered 3 days later by Officer Cogdale at 340 Thomasville Boulevard, which is in southeast Atlanta, with now bullet holes in the car that weren't in there previously. And then next, Your Honor, we have on February 7, 2022, in which officers were doing an operation to arrest Mr. Eppinger on the armed robbery warrants from October 12, 2021. They had plans, an operation in order to get Mr. Eppinger arrested. It started off with some surveillance at a house off of Clear Drive. They saw Mr. Eppinger leaving that house. There was one officer, Storno, or investigator Storno from the gang unit, who gave information to some of the other officers that were helping with this detail. Those officers included Officer Rodgers, Officer Teasley, and a number of other individuals who were preparing to participate in assisting with this incident. And what essentially happens, Your Honor, is Officer Sergeant Johnson was able to, he was doing something else, but he was able to get to the Cleveland Avenue area within moments of this occurring. As I said earlier, Officer Storno was following Mr. Eppinger, giving updates on his whereabouts. They eventually ended up at 221 Cleveland Avenue, which is the Chevron gas station, which sits at the corner of I-75, 85 and Cleveland Avenue. Mr. Eppinger walks into that store. Sergeant Johnson's able to have eyes on him to update what his movements are.
Sergeant Johnson?
We have Sergeant Johnson, Officer Rodgers. So Sergeant Johnson first gets on the scene. He's able to update the other officers about Mr. Eppinger's movements. Mr. Eppinger leaves that location and begins walking towards the apartment complex, which is Colonial Drive. At that time, Officer Rodgers, who's in his marked police car, is following behind. He sees Mr. Eppinger walking in. Officer Rodgers then, in his patrol car, begins to follow behind, entering into the apartment complex, Your Honor. At that point in time, this is where the video picks up, Your Honor.
Right, and this is Officer Rodgers' studio, right?
Yes.
61, 70, 61, 61,
Your Honor, what you see happens is Officer Rodgers in his marked uniform, Your Honor. He is in the marked uniform. He sees Mr. Eppinger. He tells him to get down, get out. He's in his marked patrol car, in his marked gear, similar to something when he has on today. He is in the courtroom today, Your Honor. When he gets out, Mr. Eppinger does not follow or comply with any instructions, Your Honor. He asks to put the gun down, get out the car. Mr. Officer Rodgers actually, in what you can't see, is actually trying to go from his firearm to his taser in order to reduce force. When Mr. Eppinger takes out a gun from right underneath his arm, this is where he's holding it, turns around and begins shooting. At that time, Sergeant Johnson had came in right behind him. And so I'm going to show you this angle, Your Honor, so that you can see what actually transpires in another angle. And when you see Sergeant Johnson that's him on the left-hand side ducks, Mr. Eppinger returns fire back towards him as Sergeant Johnson is trying to protect Officer Rodgers, because he has now shot Officer Rodgers 6 times. Officer Rodgers has 6 gunshot wounds, 4 to the right shoulder, to the posterior thigh, and 1 right and posterior scalp. I mean, it almost grazed his head, Your Honor. Only by the grace of God that Officer Rodgers is still here with us today. At that moment, officers did not wait for ambulance. They actually put Officer Rodgers in Investigator Storno's vehicle, who arrived shortly thereafter, and then transported him to Brayton Hospital. Now, this is Mr. Eppinger and phone call after.
What the hell you think? I don't give a fuck about Luke work. I really want thinking, bro. That shit happened so fast, bro. That shit happened so fast, man. I'm so hot out on me, ran out on me with me. I could see that shit. I was seeing that shit like, yeah, I'm like, that nigga been pretty good. Nah, bro. That wasn't bad. Everybody keeps on my house tripping. Hell nah, they can run out on you. Could have clicked on you, but there you gonna be. You on phone? So what you gonna tell them folks? I ain't gonna tell them folks shit. Man, you and then you start, and then you gonna tell them folks. Nah, boy, you funny as. I'm like, what you gonna tell? So, bro, listen, bro. I'm gonna hear you gonna say, cause you ain't got no explanation, boy. No, what they mean, man, listen. Hey, don't be in run up on me pointing their gun at me, man. I might get out. I'm getting out, boy. I ain't getting out. Somebody told me they call it 12 in the ass up there. Yeah, somebody, I don't know who it was, though. Who was all up there? They said it was an informant. I don't know. Somebody wasn't some folks, though, son. Little problem. Somebody wasn't some folks. Oh, damn. Breathe. Yo. The police, they ain't done ever. You said what? And the police, they hate you. Man, you might not know my name, bro. Hey, I'm calling you ain't going for that shit, bro. I ain't just talking, bro. I just want to ask you just to tell you really make all this type of shit you do. I just want to make sure that shit ain't, you know. Man, it's all snake again. They ain't touch me. What the fuck, man? Y'all know me, bro. Come on, bro. Y'all know me, bro. I'm not going out there in or out there, bro. That's it. I said that shit too. I said, you ain't get free not to go out for that. Well, they give me talking shit like, oh, you ain't ever going home. So, when your partner side, what? What they said you never going home? Yeah, you know they trying to give me lighter, bro. Yeah, I know. Man, what the hell, man? Free BBT, free. I ain't even trying. I ain't trying to be in my for my life. I damn sure was trying to be dead. But if you would have got a call when you saved, it would have been different, bro. I thought it was just rain. You mean? Yeah. Man, I got scared. You could have blinked on me. I thought I was with a gun. That's why I lay down. You got that with a gun? Yeah. People pop. Yeah. Yeah, I ain't gonna keep talking about that shit on his phone, though. I just call it. Yeah, I just speak. Hey, Chris. Yeah, I miss y'all young niggas, though. Y'all my favorite young niggas, boy. Man, look to your ass stupid hell, man. Chris, you don't got all like a phone and shit, bro. I'm just running. Nigga playing off his phone. I know. He's talking about whoever caught my phone at round one, y'all count our days. I seen that shit before I got locked up. I know. This is why I need y'all to do me a favor, though. What's up? I need y'all to drop one of the phones right quick, bro. My shit is going up, bro. Yeah, let me go look at your face. Nah, they go look at my views on YouTube. You got a phone down there? No, I ain't no phones in my street. I'm on my tablet.
So you're on while on the phone,
What's the worst name is, man?
you heard him laughing about the fact that he shot Officer Rodgers, and then Callis' mouth at the end, he's worried about his YouTube views going up and wants everyone to go on YouTube so that he can now be more famous for what he just did as part of this YSL gang, which is injuring an officer while he was trying to do his duty. But it doesn't stop there because he gets praised for it.
Yeah, man, free my nigga Big Breach, man. Yeah, man, I was saying that. Fuck that boy, spank that baby. Yeah, man, free my nigga Big Breach, man. Fuck the DA. Yeah, we about to get that fun for nigga. We came to catch you. You know what it is. Yes, sir. It's a little free game. Yeah, YSL shit. Yeah. Slap big. Yeah, man. Slap, man. Free game. That nigga for a blind, though, so that nigga for a blind, okay. Yo, it's on the jump court. Yeah, man, you might need a big bridge, man. By the way, the game way. Big bridge was a big hit, man. They gave my nigga a bun today, man. Stand me. What is it? They gave my nigga a bun today, y'all. Shit crazy.
And that was Rodgers Ryan, while he was in prison, posting YSL the gang way because he was receiving bond for this horrible act that he committed. And then we have on February 22nd, 2022, while Mr. Eppinger is in custody at the Fulton County Jail, which is now count 47, count 48 of the indictment, Your Honor, conspiracy to commit murder. On February 2022, Jada Myrick had stabbed Rayshawn wife and Lucy Bennett while in custody, Your Honor. And that is Mr. Bennett on the right-hand side, and this is a screenshot of the video of that stabbing that occurred on February 9, 2022. Given that Mr. Meyer did not complete the task at hand, which was, we believe, to kill Mr. Bennett, Mr. Eppinger wanted...
I got that poke Lucha ass up. Oh, no, hell no, I didn't do it. I didn't do it. I ain't do it.
What area you in?
Yo, they already tipped your ass off. No, I'm in Rice Street, man. Oh, yeah, Rice Street. Yeah. Oh, but you don't see that, bro. They say you ain't got down pop these ass. Nah, hell no, my little partner pop.
And that little partner was Jada Meyer. But since he could not finish it, Mr. Eppinger wanted to take on the task.
Yeah, that shit upstairs though. Oh, they got me on PC with the boy Luch. Oh, they was on PC. Yeah, hey, find out what I can get for that, bro. Huh? Man, find out what I can get for that, bro. Just what? You know what I'm talking about? I know what you get for it. I just told you why I'm at. Okay, so what you need me to do? Find out what I can get, man. I just told y'all the woman to go with. We gonna go with. Lucha, nigga. Oh, you in the drama? Yeah. No, I'm gonna make a call right now. I'm gonna let you know. I'm gonna let you know when you gonna make a call back. Man, I call that any time, bro. I've been trying to call you, bro. I bro. I know if one nigga gonna make it to the straight up, Obama gonna do it, bro. Obama gonna make it do it. Man, yeah, you know that, but we got down. I'm gonna just put some. I'm gonna put something to 4 years and see. You know what I mean? What they gonna send to you? You got down. What you I need a lawyer, bro. I need a lawyer and right. Yeah, you do. And that's a big deal right now. If you get that boy, so yeah, I don't see nobody not fucking with you, bro. You have that business, bro. That's what I'm saying, bro. I was trying to get my dollar number so I can have that slime, man. I know I was gonna hop in about that shit on the phone, but he's gonna catch nigga drip just like you get caught. I'm gonna pull up to the Yoda tonight. Bro. I'm just for it out. I'm gonna pull up to the Yoda tonight. That bitch ass supposed to be sending something, bro. I'm gonna pour a shout to the side so one-on-one shit is the after job. Yeah, bro. They tell him my situation too, bro. I already know he done heard about it. You know I'm gonna tell him, bro. You know I'm gonna tell him I got you, bro. Yeah, who all right now?
And Your Honor, so he was talking to Antonio Sumlin on that call, and some key things that I want to point out in the call is Mr. Eppinger says, I was trying to talk to Dolly so I could talk to Slime. From the previous trial, you know that Dolly is Mr. Jeffrey Williams' sister, and Slime is the name that they call Jeffrey Williams. So it's the state's belief that he was trying to reach Dolly so he can reach Slime to find out whether or not, if he does this, can he get a lawyer? That's the only thing he was asking for payment was a lawyer. And you see here, Mr. Sumlin again has his YSL tattoo on his chest, and Mr. Eppinger has the YSL tattoo on the side of his face. Again, showing that all of these crimes are in furtherance of this gang, YSL, in furtherance of this enterprise to continue to wreak havoc on the Cleveland Avenue community and the community at large, Your Honor. So we believe that would be the evidence that the state would present if we were to go to trial on this case today, Your Honor. Earlier I did speak. He did not have, for the 16 SC case, Your Honor, he did not have a special condition to stay away from gang.
Okay.
However, what he did have was the violation of the general condition, which he's to avoid persons or places of disreputable or harmful character, Your Honor. And then, as it relates to that case, there were other conditions that he violated. He never reported to probation upon release. It does not appear that he ever enrolled in the next level boys academy. So those things that he was supposed to do, he did not do at the part of the Your Honor.
All right, thanks for that clarification.
And Your Honor, he gave a recommendation now, or your recommendation?
Now, I'd like to hear your recommendation. I'd also like to hear what his criminal history is right now, other than what we've already discussed, because I believe he's maybe got some other convictions.
No, Your Honor. So his only criminal conviction now is the robbery. He was revoked. His first offender was revoked, Your Honor, and he was resentenced on April 22nd, 2022, and he received 45 years to serve on the resentence, Your Honor.
All right.
And he had juvenile history, Your Honor.
What's his juvenile history?
We do not have any juvenile charges.
Okay. What's the state's recommendation?
Your Honor, the state's recommendation is to ask count 1, conspiracy to violate the RICO Act, 20 years to serve. As to count 27, armed robbery, 20 years to serve, concurrent to count 1. Count 29, possession of a firearm by first offender probationer, 10 years to serve, concurrent with counts 1 and 27. Theft by taking, 5 years to serve, concurrent with count 1, 27, and 29. Attempted murder, count 32, 20 years to serve consecutive to count 1, 27, 39, 31. Count 33, attempted murder, 20 years to serve consecutive to count 32. Possession of a firearm by first offender probationer, 10 years to serve concurrent with count 33. Possession of a firearm during the commission of a felony, 5 years to serve consecutive to count 33. Count 39, participation in criminal street gang activity, 20 years to serve concurrent with count 33. Count 47, conspiracy to commit a crime, 10 years to serve concurrent with count 39. And count 48, participation in criminal street gang activity, 20 years to serve concurrent with count 39. So that means 65 years to serve. We're asking that to be served consecutive to his probation violation, which is 16 SC 143618.
143618.
Yes, Your Honor. And Sergeant Johnson would like to address the court at the appropriate time.
All right, you can do that motion.
I'm sorry, Your Honor.
You can do that now.
Morning. Appreciate you. Discuss this.
Do we want to take the witness stand? That might be easier. Okay. Yeah.
My name is Will Johnson, WILLJOHNSON. I'm a sergeant with the Atlanta Police Department Homicide Unit at the time of this event, I was a detective with the APD gang unit. I was operating undercover capacity, just kind of laid out the event. I mean, you've seen the video. And just my background, I've been in the department for 18 years. Prior to being in APD, I was in the Army. I was in 75th Ranger Regiment. I have 4 combat deployments. I've been in firefights, gunfights, grenade fights, rocket attacks, IEDs, car bombs. I've had a lot of experience with trauma. I think this is the most traumatic event that I've ever experienced in my life. And I think and it's not because of a gunshot, somebody getting shot, or I see this all the time. It was just the intent and the act. It was an execution. It wasn't an attempt to get away. It wasn't a fight or flight type, or it wasn't a flight in the fight, right? He was trying to fight. He wanted to kill this officer, and he made every attempt to do it. He didn't take a shot and run. He stood there and fired round after round after round into Officer Rodgers. And it was probably one of the most helpless events that I've ever experienced. And he didn't even run until he started getting shot at, and then he fled like a coward. And so I think about this day all the time. It comes back and forth in my brain all the time. I know it's Officer Rodgers who does the same, and it's probably not going to change. I think back to like when I approached him. I remember like the look on his face, and I've seen that look so many times, and it always ends in death. And so when I looked at David, I thought, yeah, there's no way he's gonna live. There's no way. He had that glassy look, that stare that was just gone. The light was out, and we tried everything we could on scene. He was shot so many times. So there's so much blood. I remember there was just so much blood. I could taste the blood, the iron in the blood. Like I tasted it for like 2 days. And so I remember my clothes. I was just like, that was the other thing. I remember I was just covered in blood, like from chest down. I'm sitting here covered in blood, and I'm sitting here for like hours afterwards, covered in this blood, smelling this blood, and waiting to make statements and everything, and not even knowing how he was doing. I'm thinking he's dead, and this guy just got away with it. And so I guess I'm just here to ask you. I mean, so like our ability to do this job, and when I go to work every day and put on this uniform and kiss my kids goodbye, like we don't know if we're coming home. And we accept that to an extent, right? That's kind of part of our job to just be prepared for that. But our ability to do that is backstopped in the belief that you, Judge, and the courts are going to show up for us the way we show up for you. And so that's basically what I'm here asking, is for you to show up for us and to provide whatever, I didn't even catch what the max was, but whatever the maximum sentence that you could provide would be appropriate in this offense.
All right, I appreciate you sharing that.
Thank you.
Officer Rodgers was present for when he did not want to say.
Yeah, and I actually recall Officer Rodgers' testimony from the prior trial. All right, Mr. Johnson.
Yes, Your Honor. Before you stand against the Christian Eppinger and before the 25-year-old lifetime of resident, Your Honor, and as an attorney, I want to thank you for the opportunity to provide this plea today, the opportunity to represent Mr. Eppinger. As an attorney who was here from the beginning of the first trial, I have a unique perspective of this entire case, Your Honor. And I just want to extend my appreciation to all the members of the state and their tireless work on this particular matter. Your Honor, however, we must say, this entire case, as evidenced by the state's recommendation and evidenced by the officer who just testified, this entire case has been a witch hunt against Mr. Eppinger solely because he was involved in a situation with an officer. The reason I say that is the state just presented to you a timeline of events. If we go back to the first event in 2016, Your Honor, Mr. Racketeer testified at the original trial. In that case, and nowhere in the discovery is there any mention that the other individuals that were with Mr. Eppinger, that they were affiliated with YSL, that Mr. Eppinger was wearing any red clothing or anything else, that Mr. Eppinger had the YSL tattoo on his face. The car was recovered shortly thereafter, so there is no showing that this automobile was stolen to benefit, profit, or to help YSL in any way.
All right, now that's the 16 SC case.
Yes, Your Honor.
That's already been taken care of.
What I'm saying is, Your Honor, that is alleged in this case as Act number 61 for the RICO count. So what I'm saying is, they are alleging that that is part of the RICO, and there is no allegation whatsoever, any facts that my client was affiliated with YSL at that particular time. So moving forward to the other incidents on this case, Your Honor, there's a situation involved, the October 12th armed robbery in this case. And we'd like to point out that my client is charged with these particular offenses. And it also is evident that, as I said, the state is attempting to get Mr. Eppinger because there was a co-defendant on these charges as well, Your Honor, Mr. Durante Beebe. And the state recommended a sentence of 10 certified for Mr. Durante Beebe for these charges. And I think that is very important because Mr. Durante Beebe was the individual who was immediately identified by the victim in this case. He was identified somebody.
All right, folks, I had to jump on because, yeah, it seems it's over. He is pleading guilty. Not sure which charges. I assume Judge Whitaker will go through it.
Facial pictures, but
Sorry,
also by physical disfigurement on his hand. And it's important to point out that the victim in this case
I
is
can't.
Darius Hill, who would have testified.
Sorry that I can't show my face at the moment, but hey.
In this case, additional evidence would have come out that his initial report to the police officers, he gave a description of an individual that did not fit Mr. Eppinger's description. In his first conversation with the officers, when he went to the police officer, he identified another individual as being the person who perpetuated the crime. He stated that he was given that information because this was word on the street. So there was no viable information to identify Mr. Eppinger as a participant in this crime. Later, the officer who would have testified as Matthew John Pierre, who was the leading investigator on this case, Your Honor, he would have testified that they received an anonymous tip telling them that Mr. Eppinger had been involved in this situation from a person who alleged to have viewed the robbery. Your Honor, the witness in this case testified that the individuals who perpetrated the robbery were wearing masks and he could not identify them. So it's very hard to say that an anonymous tip who says that they saw this in masks would have been able to identify Mr. Eppinger. That is why Mr. Eppinger's name was involved in this particular case. And subsequent to that, the witness went in to meet with the police officer to identify a photo lineup. Mr. Eppinger was identified in that photo lineup. However, Your Honor, the video, if this matter went to trial, the video of that interview would have shown irregularities by Mr. Matthew John St. Pierre in conducting this lineup, where when presenting the information to the victim, he took Mr. Eppinger's picture from the bottom of the stack, placed it on the top out of order, and then shoved it in his face for him to make a selection, at which time he picked Mr. Eppinger. He had no prior information regarding Mr. Eppinger. He did not know Mr. Eppinger or anything else like that. And that is very important, Your Honor, because the state in this matter is alleging that a video that you heard Mr. Eppinger that was made on October 16th is him bragging about this robbery. In that video, you hear him saying that, you hear Mr. Eppinger saying that he has contacted a person attempting to sell something or whatever. That is important because that video was made on October 16th. The identification of Mr. Eppinger was not made by Mr. Hill until October 20th, Your Honor. And at no point in his conversations with him had he mentioned that he had been contacted by the person who tried to who had robbed him, that there was an attempt to sell back anything. And then also, Mr. Eppinger on the video stated that the person he was attempting to sell the chain to was coming from Henry County, and Mr. Smith states that he lives in Forest Park. So he would not have been coming from Clayton County, Your Honor. So there are numerous inconsistencies. Nowhere in that video is Mr. Eppinger mentioned being involved with a co-defendant in conducting this robbery, as Mr. B. We know Mr. Eppinger was present. Nowhere does he mention conducting the robbery with another individual, and nowhere does he mention taking a van or anything. And also, Your Honor, in that armed robbery, that van was recovered shortly thereafter too, so there is no showing that the van was taken to be sold for YSL benefit, to be sold for YSL transportation, or to benefit anything other than possibly the individuals who took that car taking it for a joyride at that particular time. Mr. Smith testified that his car was ransacked, but it was not damaged. So there were no items stolen off of his car or out of his vehicle.
And that's the count, one of the counts that's being not crossed, right? The hijacking motor vehicle.
Yes, Your Honor.
But it goes to the armed robbery, Your Honor. It's very
I
important.
understand, I'm just trying to make sure I got it all.
Because, Your Honor, why that's very important is because, as I stated before, Mr. Beebe, the co-defendant of these charges, was allowed to plead to a reduced charge of robbery and given a 10 to 5 cents in this case. The fact that the state is unwilling to do the same with the co-defendant in this matter, Mr. Eppinger shows their intent toward Mr. Eppinger wanting him to serve the mandatory minimum on the armed robbery sentence, which, given in light of the probated sentence that he has right now, is a mere formality unless it's run consecutive, Your Honor, I'd like to point out. And Mr. Eppinger's probation was revoked, as the state stated before, correctly. He did not have any provision that he was supposed to stay away from any gang members because there were no gang charges in his first crime. And the allegation that he was supposed to stay away from individuals of ill repute or harmful character, Your Honor. The individuals that hang with are individuals in his neighborhood. He's a 17-year-old child. So I'm sure he does not know the criminal records of everyone, of all the children and teenagers in this community. No, I'm not supposed to be with this guy because he's a harmful character or anything else like that. But we'll point out, prior to this incident that involved the police officers, there had been no revocations of Mr. Epinger's probation and no other arrest warrant. He was arrested for this, and all of this came to light. Now, Your Honor, you saw the video, as stated before we go back to finish up on the armed robbery situation. As I stated before, Your Honor, if the matter did proceed to trial, we do believe that there will be sufficient inconsistencies with Mr. Smith's testimony, numerous things that could possibly invalidate his identification of Mr. Eppinger in this particular case. At this point out, these additional facts, while we do believe that they are present, they may not be enough to carry the day, which is why we believe that this plea is in the best interest of our because we do not believe that the state's presentation of the facts are 100% accurate and that their evidence is 100% solid. We do believe that Mr. Eppinger does have a defense in this matter, but the uncertainty if this matter was presented to trial is the reason which we state that this matter is within Mr. Epinger's best interest.
Okay, and a part of Alford is essentially an acknowledgement that while you are not conceding guilt, you are acknowledging that there is sufficient evidence from which a jury could conceivably find guilt beyond a reasonable doubt, correct?
Yes, Your Honor.
And you've discussed that with Mr. Eppinger.
Yes, Your Honor.
And Mr. Eppinger, you agree that the facts are such that a jury might find you guilty of all of this? All right, go ahead.
So, yes, Your Honor. And we would then like to proceed to counts, the most important counts in this case, counts 32 and 33, involving the attempted murder in this situation. Your Honor, I've practiced law for over 20 years now. Majority of the times when an individual is shot or shot at, that's an aggravated assault. Most times. In this particular situation, the state has chosen to step into the mind of Mr. Eppinger and say that he had the intent to kill these officers. In this particular situation, charge him with attempted murder. One officer who was not even struck by any bullet or anything else like that. So we do believe that he has been overcharged simply because the district attorney's office, from the beginning of this case, has used inflammatory language and rhetoric in this particular matter. In the initial interview, the initial press conference regarding this situation, they said that Mr. Eppinger attempted to assassinate this officer. As you heard the video yourself, Your Honor, you saw what happened. This matter happened in a matter of seconds. There was no pre-planning. Mr. Eppinger wasn't out there trying to get anybody. He didn't know anything about this warrant. He didn't know that they were looking for him. He had no idea any of this was going on in this particular day. Because as he contends his innocence from not participating in the armed robbery, Your Honor, he would have had no idea that there was a warrant for his arrest. And you heard on the video, at no point in time did Officer Rodgers identify himself. At no point in time did he say, I have a warrant for your arrest. If you heard the video on the first trial, you heard it again today. At no point in time did he say that. And Your Honor, would also like to point out that at no point in time, excuse me, do you have a speaker? Your Honor, one thing about it, and I've showed the state marking it as defense exhibit number 1 for the purposes of this hearing, Your Honor. You have heard numerous times that at the time of this shooting, that Officer Rodgers was uniformed. That is incorrect, Your Honor. That is a blatant fallacy. If I may provide to the court exhibit number 1, I'll show to the state. Your Honor, this is a photograph that was taken from, that is a capture, that is taken from the body camera of Officer Storm, who the state has admitted was present at the scene. And that is a picture of Officer Rodgers laying in the grass after the officers had moved him to a safe position after he was shot. As you can see, he is wearing a hood, he is wearing a mask, and he does not have his badge on the front. He was not in his full uniform at the time of the shooting. In no shape, form, but that is what Mr. Eppinger saw that day, Your Honor. He did not see an officer in his uniform, as been said numerous times. He did not have any of the uniform that the officers were wearing his day. He was in an undercover capacity who charged out of his vehicle at Mr. Eppinger.
Out of his marked patrol vehicle, right?
From behind, Your Honor. Yes, I admit that it was a marked patrol vehicle, but he approached Mr. Eppinger from behind, ran out of the vehicle with his gun drawn, attacked Mr. Eppinger, did not follow police procedures. He did not identify himself as being an APD officer. He was not in the uniform, and he knew at no point in time did you hear me say, "You have a warrant for your arrest." You heard him one time say, "You got paper." However, Your Honor, we will contend, and I'm sure the evidence will show from the gang experts that will testify in this case. On the street, paper does not mean warrant. Paper means money. So therefore, saying you got paper was not indicating or giving Mr. Eppinger any knowledge that he has a warrant for his arrest. And any indication is shown, Your Honor, at his prior arrest, his prior conviction, when he was arrested before, he was taken into custody without incident. The officers informed himself, showed him that he was taken into custody without incident, so the state cannot allege that, oh, he's just this big bad person who attacks police officers. Subsequent to this, as the officer testified that, oh, we thought that he was going to get away with this, that officer was in the hospital at the time. He had no knowledge that Mr. Eppinger didn't even leave the complex. He was taken into custody. Probably by the time that they had gotten to the hospital, Mr. Eppinger was taken into custody. So
After the house that he was hiding in was surrounded by officers, correct?
Yes, he was taken into custody without incident at the time. He attempted to hide. We admit that. He attempted to hide as a scared child at the time. And therefore,
How old was he at the time?
22. Your Honor, so in this particular situation, as stated before, the officer did not follow his procedures in doing so. And Mr. Eppinger did not know he was an officer at the time that he was attacked. When he came out, he had his gun drawn on Mr. Eppinger. So it's safe to assume that Mr. Eppinger's focus would have been on the gun that was presented to him in receiving order. Get on the ground with the person not identifying himself. So we do not believe that this is a situation where he was intending to kill anyone. And Your Honor, taking into consideration that this matter, this entire case, is a 65-count indictment that has been levied down, Your Honor. And in this matter, there were 2 counts of murder, another count of attempted murder in this matter outside of Mr. Eppinger. All of those matters have been reduced by the state. All of those matters have been reduced. So what the state is saying is that the lives of their citizens are not as important as that of police officers, because we'll reduce the murders of people who we know are murdered, but we're not going to reduce for the purpose of the plea for this particular matter for Mr. Eppinger.
All right, 15 of the counts are against your client, right?
Yes, Your Honor.
Okay. And at least 4 separate incidents against your client, right?
In this particular matter, yes, Your Honor. Four separate incidents, Your Honor. And I point out, in none of these situations has anyone died in any of these situations. Now, as it relates to the theft by taking, Your Honor, that matter, as it relates, I spoke to Mr. Eppinger, is probably the matter in which he has the least amount of defense or facts in his favor. It's not, the video is pretty evident. You see Mr. Eppinger from the video, into the vehicle, so we'll move on from that. As it relates to the last matter, Your Honor, the issue involving the conspiracy, you heard Mr. Eppinger on the telephone make a phone call, and the state is interpreting. Never does he say anything about Mr. Bennett, never does he say anything about killing Mr. Bennett or anything else like that. The state is making the assumption that this is what his words mean. However, the facts are, as stated before, he was speaking to Mr. Antonio Sumlin. Mr. Sumlin, on whose matter was charged to get Mr. Evans' attorney or anything else like that, or anything was done, or there was any substantial step based on that initial offer to do it, and if it is to be construed as an offer. Our contenders from the defense would be that it was not an offer, just a conversation, but the state is saying that he was offering his services to possibly attack Mr. Bennett, and they assume that it's the murder of Mr. Bennett, Your Honor. However, there's no showing that Mr. Evans has ever made an attempt on Mr. Bennett's life, that there was any kind of order given down from the top or passed through any other parties or anything else, that there was an agreement between Mr. Evans or anybody else to harm or attack Mr. Bennett. So as such, in this particular matter, taking into consideration the fact that Mr. Eppinger is currently serving revocation of his probated sentence for these particular acts right here, Your Honor. His probation was revoked solely because of these acts.
Okay, his probation was revoked and he was resentenced.
Yes, Your Honor. He was originally resentenced to 66 years. That matter was appealed and reduced down to 45.
Yeah, so Mr. Eppinger is already serving 45.
I said there are issues with regards to Mr. Smith's identification of Mr. Eppinger as it relates to the armed robbery and the hijacking charge. As it relates to the attempted murder, Your Honor, I do not believe that there is a requisite intent to kill in this particular matter. As pointed out, the state is intending to stay focused every time that Mr. Officer Rodgers was shot 6 times. 4 of those shots were in the shoulder, Your Honor. In his right shoulder, one in his leg, and a grazing wound in the back of his head, which is not meaning that came from a direct shot, given the fact that placement of where his wound was in the back of the head. That bullet could have been introduced through medical evidence that the bullet could have ricocheted off of his shoulder, which was shattered by being shot 4 times, and possibly grazed the back of his head. If you look at the video, at no point in time is Mr. Eppinger behind Officer Rodgers to shoot him in the back of the head, so therefore, a direct shot, we know he did not shoot him directly in the back of the head whatsoever. Advancing was a grazing wound that went past the back of the head, which is not determined as exactly how that may have happened. And that's one before you heard Mr. Eppinger state from a phone call of Mr. Eppinger at jail. He said, laugh, when they put on the screen, laughing about attempting to murder. Your Honor, that is basically a far-fetched to say what Mr. Epinger's intent was based on this conversation on this telephone with this other individual. It's not reason that he intended to murder this individual. He had no knowledge of whether or not this officer was dead. He shot him in the shoulder. At no point in time, given the close proximity that they were, at no point in time if Mr. Eppinger wanted to kill this officer, he could have shot him in his chest or he could have shot him directly in his head. There was nothing preventing him from doing that. Nothing.
Maybe he's a bad shot.
Or Boyer Runner, maybe he's a good shot. The fact that he was placed forward in the shoulder, that shows a very tight movement around. We're not going to get into that. However, the individual was shot. But at no point in time did he shoot him in any vital organ or anything else like that. As far as the shot in the leg, Your Honor, the most damaging part of the shot in the leg would be if the bullet would strike the femoral artery. Given the fact that the average human thigh is approximately 7 to 8 inches, Your Honor, and the femoral artery is approximately 10 millimeters in width, there's no way that he can intend to hit that particular, by shooting it, that I'm definitely going to hit the femoral artery in an attempt to try to kill somebody, Your Honor. So, the saying that Mr. Eppinger was attempting to try to kill anybody in this situation, we do believe is a stretch, especially in light of the fact that the officer is not in uniform at the particular time. Also, Your Honor, I'd like to point out that in this particular indictment, we do believe that this entire case, and I can say this now, culmination of it, has been somewhat of a witch hunt, Your Honor. This case involved a 65-count indictment with 1 count of RICO, that leaves 64 other counts. There was 21 possession of firearm charges and not 15 gang charges, Your Honor. So therefore, if you look at the remaining charges in this case, there are mentioned 15 charges involving violence over a 7-year period. 15, Your Honor. There were 3 counts of attempted murder, 2 counts of murder, 4 counts of armed robbery, 2 counts of hijacking, and 4 counts of aggravated assault alleged in this entire indictment, Your Honor. And all of the murder charges and all of the armed robbery charges have been reduced to either aggravated assault or robbery. However, the state is unwilling to do so on behalf of Mr. Eppinger. We'd like to point out, As they allege in this matter that YSL is a criminal street gang, Your Honor, I'm sure that if the evidence, if this matter proceeded to trial, each one of the gang experts would testify that association or membership in the gang in and of itself is not illegal, Your Honor. So the fact that Mr. Eppinger may have been seen posing with individuals on Instagram and wearing a certain type of clothing in and of itself is not criminal. There is no showing that any of the crimes alleged by Mr. Eppinger have been tied in back to YSL in any way other than his alleged membership in it, Your Honor. They have furthered the interest of the gang in any way, financially, status, or anything else. Ms. Hill, the victim of the first armed robbery, Your Honor, was not shown to be an adversary or anything of YSL. Mr. Smith, the individual who was robbed in October 21, was not shown to be an adversary of YSL, or that this was done to further YSL in any way, Your Honor. And so therefore, they're alleged that YSL operates over the Cleveland Avenue area, which is in Zone 3, Your Honor. So before I became a lawyer, I used to be a scientist, Your Honor. So I took out my legal hat and wanted to look at the numbers and look at things analytically, Your Honor. In this particular situation, in Zone 3, which is allegedly the YSL stronghold, over the life of the RICO, from the time that they allegedly began on January 24th, 2013 to the time of Mr. Williams' arrest on May 8, 2022, there were 239 murders in Zone 3. However, citywide in the city of Atlanta, there were 987, so therefore, the murders in Zone 3 only represent 24% of the total murders in the city of Atlanta. As it relates to armed robbery, Your Honor, they only had 19.8% in Zone 3. As far as auto crimes, as far as auto theft, only 19.6% of the total crime in Atlanta. Aggravated assault, Zone 3, where they allege the YSL stronghold only represents 25% of all the aggravated assaults in the city of Atlanta. So these 7 events of violence in this case,
That would mean
2 of which are
shift
associated with
officers doing craft investigation.
From January 10, 2015, which was the murder of Mr. Donovan Thomas as alleged in count 2, to March 14th of 2022, which was the alleged murder of Mr. Chanel Prince in count 49, there were these 7 events that we were referring to in this situation. So we contend that, as it points out, that we were aware Mr. Eppinger was on first offender probation, so he did not have an extensive felony criminal history before this.
Because he'd been a juvenile before that.
Well, you are also, speaking of a felony criminal history, not access to the juvenile.
Well, I mean, the court's supposed to be able to have access to it for sentencing purposes. It just hasn't been presented. But what I'm saying is, yeah, I understand that the 2016 armed robbery reduced to robbery, and now that he's been resentenced on was his first felony conviction. But you also, unless you commit a limited number of crimes as a juvenile, can't have a felony history until you pass a certain age.
Well, we'd also like to point out, Your Honor, that at the time of their arrest in this situation, the person who was the co-defendant with Mr. Eppinger had many more arrests and more convictions at the time. Last he was sentenced to 10 to 5 for that matter. And Mr. Sumlin had more arrests than Mr. Eppinger also. He was given 15 years probation. So moving to what we believe is a proper representation in this case, Your Honor. Given the fact that the state is enforcing Mr. Eppinger basically pleads to everyone in this particular matter. As to count 1.
All right, hang on. The state's not forcing Mr. Eppinger to plead to anything. I've got a jury waiting next door, and we can strike a jury right now if you'd like to go to trial.
What I mean by that, Your Honor, Mr. Eppinger wants to take the plea. Mr. Eppinger believes that the plea is in his best interest, Your Honor. We believe that the court will be consistent with their rulings and consistent with their fairness that they have shown throughout the course of the trial. So we believe that the case is best interest to do so. What I mean by saying that the state is forcing it, Your Honor, there have been numerous plea negotiations in this case, negotiated pleas and non-negotiated pleas, Your Honor. In fact, there have been, 25 pleas that were taken in this case, as only 2 individuals went to trial to murder. So there have been 25 pleas taken in this case for dismissal in this particular matter. I'd like to point out that none of those pleas did any individual receive simply sentencing to one consecutive to sentences that they already have. I believe the most stringent one was the last plea that was taken for Mr. McMullen, who was reported to 20 that was going to concur with his current sentence that he has right now. So, taking that into consideration, what I mean by saying forcing is to plead that I'm not saying they're forcing, but the state has been unwilling to negotiate with regards to the reduction or the dismissal of certain charges, as they have with other cases.
My recollection is that the last offer by the state was to 2 consecutive life sentences, so it seems to me like they've definitely come down from that.
No, the 2 consecutive life sentences in the form of Mr. Eppinger was the maximum. The first offer that we were given in this round of things started with your
Okay.
Then they came down to 60 consecutive, then it's 40.
All right, well, I hadn't been privy to all of that. The last one I heard was, okay, 1 and not 2 life consecutives, but it sounds like they've been coming down the whole time.
Now
All right.
it's 65 consecutive.
Okay. Yes.
As it relates to count 1 for RICO, we would ask that my client be sentenced to 15 years to serve concurrent to count number 32. As it relates to count 27, Your Honor, the armed robbery, we would ask that my client be sentenced to serve 10 years to serve concurrent with count 1. The hijacking charge, count 20 years, being no cross. As it relates to count 29, possession of firearm by a first offender, we would ask that he be sentenced to 5 years to serve consecutive with count 27. The theft by taking charge, Your Honor, we ask that my client be sentenced to have a 10-year maximum, be sentenced to 5 years to serve concurrent with count 1. Your Honor, as it relates to count 32, the attempted murder, Your Honor, we would ask that my client be sentenced to serve 20 years to serve 15. We do not believe that there was an intent to murder the officer, Your Honor, so we believe that this is more in line with the factual basis of that where assault in this case. So we ask him to serve 20 to serve 15 on that particular matter. As it relates to count 33, the attempted murder, Your Honor, we would ask that he be sentenced to 10 years to serve 5 concurrent with count 32. That reflects the fact that the other officer in this matter did not receive any injuries, and there is no showing on the video that he was ever in danger of receiving it. The alleged that Mr. Eppinger shot at this officer, however, Your Honor, it is not apparent from the video that he did so, and we did not receive any information that the car that he was in at the time was struck by any bullets or any projectile was found from the gun, so we do not believe that the 2 counts, and counts 32 and 33, are factually the same. We know that is why we made a difference in the resolution of those charges. As far as possession of a firearm by first offender at count 34, Your Honor, we ask that I'm sentenced to 5 years probation on second count number 32. For count number 36, possession of a firearm by convicted felon, we ask that I'm sentenced to 5 years to serve concurrent with count number 27. For count 37, being low cross, count number 8 being low cross. For count 39, Your Honor, we ask that my client be sentenced for the violation of gang law, Your Honor. We ask that he be sentenced to serve 20 to serve 15, concurrent to count number 32. For the conspiracy act in count 47, Your Honor, we ask that my client be sentenced to serve 15 years probation, concurrent to count number 1. And for violation of the gang act, we ask that count 48, my client be sentenced to serve 15 years probation, concurrent to count 1, which, based on the estimation, we believe is a total sentence of 25 to 15, Your Honor.
Sure.
And I think that this is, like I said, fair with regards to the resolution of this matter, Your Honor, consistent with, as I stated before, on counts 27 and 28, the code of criminal procedure received 15 to 5, and 5 was a consideration because this matter was reduced from armed robbery to robbery. As it relates to counts number 47 and 48, the code offender on those matters this summer received 15 years probation on those counts, Your Honor. So as far as anything that would be varying from those charges as it relates to the charges of the shooting of the officer, as I said before, we asked that my client be served 15, and that this matter run concurrent with his probated sentence right now, Your Honor, which we believe that is fair and consistent with what's happened with the other matters in this case, Your Honor. but at no point in time has there been any allegation that Mr. Eppinger was the organizer or leader of this situation. No other defendant in this matter received more than 20 years to serve, and includes individuals that were originally charged with murder in this case. All the murder charges will be reduced to aggravated assault and double cross. And all of the armed robbery charges in this case, Your Honor, will reduce the robbery. The individual who received the largest sentence on those was Mr. Huey, who had 3 armed robberies that were reduced down to robbery. He received a sentence of 20 to serve 9. I would like to point out that in none of these situations, there is no one who has lost their life in any of these situations that Mr. Eppinger has been involved in, Your Honor. And so we do not believe that if Mr. Eppinger is not taking his life, we do not believe that there should be a second sentencing in this matter, which is effectively taking Mr. Epinger's life away from him, as he currently has a 45-year sentence, and a second sentence would basically effectively almost be a death sentence in this matter. Your Honor, which put it further. The state's recommendation would give him 110 years to serve, Your Honor, which is effectively a death sentence for an individual who did not kill anyone. And so therefore, while we consider the same individuals may think and say that, oh, well, I think the officer definitely has his right to say that he felt that Officer Rodgers was going to expire based on his injuries. The facts are, none of the injuries that he sustained were life-threatening. He was back in service sometime after he was able to come to court to testify, Your Honor. I believe he's on the force now, so he's resuming his activities, Your Honor. So if Mr. Eppinger has not killed anyone in this matter, he's standing before you today accepting the responsibility of the situation. You understand, as you said before, there is a factual basis that the facts as presented by the state may present enough for a jury to convict him, and we do believe that we have facts that could possibly go the other way as well, Your Honor. It is the uncertainty of that matter in which Mr. Eppinger seeks to avoid. He's under the understanding that if he was found guilty at trial, his fate would be in your hands, Your Honor, and we stand in that position as we are today.
Thank you.
Yep, just a few things, Your Honor. I want to correct the record. So I'm going to show Your Honor State Exhibit.
You may.
State Exhibit number.
Have you shown it to opposing counsel?
Your Honor, showing State Exhibit number 1, Your Honor, which is Officer Rodgers' vest. The video that Mr. Johnson showed you was after they took the vest off of him to perform life-saving
You leave, Miss Hilton.
life-saving services on Mr. Rodgers. So you can see on that picture, there's some blood markings on Mr. Rodgers' front of his badge. And we also have some pictures that we can show, well, they were checked out of the Zoom, but shown on the Zoom that has blood on the back of his vest, Your Honor. So when he got out of the car, his vest was on. He shot him in the vest, and so they took it off to help perform the measure, Your Honor. So that is an incorrect statement that Mr. Officer Rodgers did not have or was not in uniform, because he was in his vest that says
The
It had the
vest,
seal and his name.
his name on it, Your
All
Honor.
right.
Going
Since
to,
Defense Exhibit 1 and State's Exhibit 1 are
seriously, Miss Hilton. People wearing vests in that area does not mean they are a cop. He was in plain clothes. He jumped the defendant, called him boy several times. Yeah. And never identified himself as a police officer.
admitted.
going briefly to the armed robbery, Your Honor, regarding Mr. Eppinger and this comparison of Mr. Beebe and Mr. Eppinger. When we spoke with Mr. Smith, Darius Smith, in preparation for this case, what he advised is that Mr. Eppinger was the individual informing or controlling the armed robbery. He was the one telling Beebe what to do, that Beebe is seen afraid or scared. And so when we made the decision for Mr. Beebe, we took that into consideration because that is what the victim told us, that it seemed as though Mr. Beebe was afraid to do it, but he was following the demands and the controls of Mr. Eppinger, which you can hear when he's bragging about it, what he said he did and how he spoke to the victim, Your Honor. So we took that into consideration when looking at Mr. Beebe's resolution, and Mr. Beebe did not have a prior armed robbery, reduced the robbery, when we decided to make that recommendation. And then, as it relates to the stabbing of Mr. Bennett, the reason why Mr. Bennett was stabbed is not because he didn't have the opportunity, but because one of the law enforcement in our office heard the jail calls. They called the jail to have Mr. Bennett moved so he wouldn't be stabbed again. So it's not for the fact that he didn't do it, it's the fact that we were able to move Mr. Bennett to safety so that he did not get harmed again. So this notion that he didn't do it is because he didn't have the opportunity. Your Honor, we were able to get Mr. Eppinger juvenile history, Your Honor. So he had 2 burglaries, one from June 4th, 2015, which was almost a year prior to the armed robbery. And then he had another burglary on February 11th, 2016, so a few months before the armed robbery. He was adjudicated, it looks like the date is May 11, 2016, so we're not sure if once he was taken into custody, they adjudicated it, but they were joined for the purposes of the juvenile adjudication, Your Honor. Your Honor, my closing remarks here is that Mr. Eppinger is not similarly situated to many of the other defendants in this indictment. Mr. Eppinger received an opportunity to change his life when he got an armed robbery that he did at 16 reduced to robbery. He served 4 years in custody, and within 4 months, not a year, within 4 months, he was back to the same criminal behavior that they tried to save him from 4 years prior to that. He never learned his lesson, not once. And what does he do? He robs somebody. Then when police are just trying to do their job, he takes a gun and he's not carrying his waistband. He's not carrying where he has to pull. It's literally tucked under his arm with easy access and begins firing off rounds over and over and over again. Like you said, he's not a good shot. But bullets have no names. You know, Mr. Johnson just said, well, the bullet that went to Mr. Johnson didn't hit him. That's not, they don't have any names. And for that reason, Your Honor, the state, we believe, has been gracious in our offer. Mr. Eppinger, looking at what he's charged with, he's looking at life plus 150 years. That is what the maximum sentence is for the charge that he's pleading to. The state, understanding that he already has 43 years, which most of that will be door to door, consider that 60 years consecutive is about 103 years. And that is why we made that recommendation, Your Honor, given that we believe that is substantial time in this case. So, Your Honor, the state is going to ask that you follow the state's recommendation. Mr. Eppinger had an opportunity to change his life around, had an opportunity to go to the next level Boys Academy, had an opportunity to do all these different things, but he chose not to do that. He chose to go back into the streets, to live this life again. And here's where we are, and this is what it brought him to. And he had no remorse about it. On the jail calls, he's bragging about it. That's what he's doing. He wants to be this person in the streets. So we're asking you to hold him accountable to be that person in the streets.
All right.
Yeah, Yes, Your Honor. First off, as far as the allegation regarding the differences in Mr. Beebe, Your Honor, they showed you the photograph of Mr. Beebe wearing the chain. Mr. Beebe, there's no photographs of Mr. Eppinger wearing the chain. And so therefore, the fact that they say that the witness told them that the one person was running it, we do believe that the evidence that he's giving in the interview, we don't have a recording of what he said when he was in their office. However, the recordings that he gave to the police officer at the scene of the crime, the recording that he had with the officers later on, and the recording with the officers at the time that he made that identification says no to that, Your Honor. So therefore, that evidence in and of itself should not be taken as 100% credible. It's subject to cross-examination and discrediting as well, Your Honor. So therefore, the state is not showing a significant difference between this situation, as Mr. Beebe is the individual that had photographs wearing the chain after the incident, which would show that he's much more involved in just being the scared person standing on the sideline. He's the one with the spoilers of the crime, Your Honor, and the state has evidence of that they knew at the time they gave his plea. Also, Your Honor, as they mentioned about the fact that Mr. Bennett was moved, the state still has not said any evidence that there was any agreement for Mr. Eppinger to do this. There's no showing that Mr. Eppinger had received an order or any kind of compensation to do this. So the fact that they moved him is irrelevant, Your Honor, because there's no showing that the crime of the conspiracy was actually completed in this particular situation. Your Honor, so the fact that they may have moved Mr. Bennett and Mr. Eppinger did not complete the crime is irrelevant, Your Honor. The issue and fact of the matter is not whether he actually did it, whether or not there was an agreement prior to that for him to do that sufficient for the charge of conspiracy, which they had not done so in this particular case, Your Honor.
All right, thank you. I found there to be a factual basis for this plea, and I will accept the plea as freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences and the sentence. And let me say a couple of things. Only one overt act, as we all know, needs to be proven to establish RICO. On counts 27 and 29, I believe that the defendant's own words inculpate him in the crimes, and I note that he talked about telling the victim to take off the earrings too, which was a part of what was stolen in the case. That certainly seems to, in the court's estimation, inculpate him in those crimes as an absolute willing participant. 31, understandably, considering what we see on video, the defense has really not argued anything at all. Appreciate that, that y'all acknowledge that at least that is pretty clear. In counts 32 through 39, the video, in addition to State's Exhibit Number 1, shows the officer to be in uniform, and
I don't agree with that.
do not think that
I do
charging
not agree with
attempted
that.
murder is an overcharge, considering that Mr. Eppinger, and we hear 6 shots on the video, pumps 6 shots at close range into a uniformed officer, and then laughs about it afterwards, including saying something to the effect of, yeah, he's telling me to get down, I ain't getting down. I think that considering the prior history, the number of different...
Yeah. All of this hangs on one of the charges is against a cop. So it seems like Judge Whittaker is going to throw down the hammer on Mr. Eppinger.
incidents, honestly, almost back to back to back to back, from him getting out on first offender probation and deciding he's not going to change his life, he's not going to take the opportunity he's been given. And many of these incidents wouldn't have occurred, or wouldn't have occurred with the seriousness that they did, if he had abided by his first offender probationary condition of not having a firearm in his possession. He couldn't have shot an officer because he wouldn't have had a gun to shoot an officer if he had abided by his conditions of probation. So the number of the separate incidents, the apparent lack of remorse for any of this, the seriousness of the crimes, and the strength of the state's evidence on these particular charges, and the demonstrated determination to continue a criminal lifestyle all go into the court's sentence determination in this case.
Yep.
So the sentence
throw down
on
the hammer.
count 1 is 20 years to serve 10. On count 27, it is 20 years to serve 10 concurrent. 29 is 10 years concurrent. 31, 5 years concurrent with count 1. The sentence on count 32 is 30 years to serve consecutive to count 1. 33, 20 years to serve concurrent with count 32. 34 is 10 years to serve concurrent with count 32. I'm going to come back to 36 because that is required by statute to be run consecutively to anything else that's being sentenced. That's the only one that's that way, right, Ms. Fulton?
Yes, ma'am.
All right, count 39, the sentence is 20 years to serve 15, concurrent with count 32. 47, the sentence is 10 years, consecutive to count 32, but probated. 48, 10 years, concurrent with count 47, probated. And then 36 is going to be 5 years consecutive to count 47 and probated. I believe that is, honestly, I'm going to have to do a little bit of math right here. I think that's 75 years to serve. To serve 40, followed by 15, no, I don't know. I don't know what the math comes out to be, but
20 to serve 10 on count
20 to serve 10,
20 to serve 10.
concurrent,
Not concurrent.
10 to serve concurrent, 5 to serve concurrent with count 1. So that's a total of 20 served 10 right there. 10 probated.
Okay.
All right. Count 32 is 30 years to serve consecutive to count 1. So that's another 30 to serve. Count 33, 20 to serve concurrent with count 32. 34, 10 concurrent with count 32. So right now we're at 50, serve 30.
So 30.
Yes. If there's 30 to serve,
40.
To serve 40,
No.
because it's 20 to serve 10.
clearly this is why lawyers end up lawyers and not scientists or mathematicians, although it's
It's in the record, it was 30 to serve.
yes, consecutive to count 1, which is 10 to serve. So that's 50 serve 40 at this point. Count 39 is 20 serve 15, concurrent with 32. So that's not any additional time to serve. So, and then 47 is 10 probated consecutive to 32. 48 is 10 probated concurrent with 47. And 36 is 5 consecutive to 37 probated. So that's,
Consecutive to 47.
yes. It's at least 65 to 40.
And was that wrong? Concurrent with the current sentence?
How long is he going to actually serve on that sentence?
I recommend they 40 days.
45 years.
45.
And run currently with his sentence he is currently serving.
Yes,
All right, that
okay.
is the ruling of the court. And we are adjourned. He may be taken into.
Okay, folks. 65 years to serve 45, which is exactly the time he is currently serving in prison. The only change is that he will now, by all accounts, actually serve those 45 years. So everything added up, they got convictions, but Mr. Eppinger, nothing changes for him. He will still be in prison for 45 years. So no change. Congratulations, Fannie Willis. Out of 65 counts, 3 years of litigation, 2 years in trial, somewhere between $15 and $20 million spent and nothing changed, except a few people got probation. That's it. Meanwhile, in Fulton County, over 2,000 SA kits still untested because there are no fundings. Still in Fulton County, there are a docket of, I lost count, but it's well over 1,500 cases still, just pending. Still, Bonnie Willis is enriching herself on the taxpayers of Fulton County. 2.5 years and nothing really changed, except a few people are on probation. And then you have the injustice to Monktunk. Yeah. An absolute, in my opinion, waste of time, waste of money, because the people who are in prison now will still be in prison. And the people who weren't in prison are on probation. That's it, folks. Now, I spent the past 2.5 years on this. I told you in, what was it, May of 2023, I am going to cover this from gavel to gavel. And I did. And I did. Everybody, thank you. Thank you for allowing me to do this. Check out my other content, please. YouTube doesn't like me at the moment, so I really need better numbers. I will do a more thorough stream about the YSL trial and everything on Friday, I believe. But again, thank you, folks. You all have a good one. And yeah, I will see you in the next stream or video. Have a good one. Bye-bye.
Defending the voiceless, the wrongly accused, facing the foe whose motives are abused. In the courtroom battlefield, they'll stand tall, unveiling corruption, they'll conquer it all. Against the cutthroat prosecutor's wrath, the words like weapons cutting like a path, challenging the system that's filled with lies, seeking truth and justice in their eyes.
Whoop. See ya.